Right now, persons who are dissatisfied with the board of the directors' decisions don't want to be mandatory
to minors if the library still fails to follow the order after a final request for the library to follow its order. And lastly, it allows a county prosecutor to seek injunctive relief to require a district or city to follow the requirements of the act. So a library or a district can't simply just not do any of this. If they fail to, a prosecutor can seek injunctive relief ordering it to be done. Why are we doing this? There's been a call, and there have been repeated complaints and repeated instances and reports of material that is colorably harmful to minors being made available to them. But these objection procedures and the responses aren't uniform throughout the state. Responses to objections are sometimes conclusory, and sometimes they're not very informative. I had an objection for a city that I represent, and I reviewed the library's response to that objection. I reviewed the library board's response to that objection, and then I began to prepare myself to respond to that patron in case they weren't satisfied with either of those decisions. And that's kind of where I hatched this idea. Right now, persons who are dissatisfied with the board or the director's decisions don't have any mandatory recourse, except to get on the open mic night at a board meeting when the board is trying to conduct business. And the 3-minute open mic period, or they flood the open mic period, and sometimes that gets out of control. People get heated, and it can derail the business of the board. This allows a process where you can have a separate meeting dedicated solely to this task and not divert the resources of the board in conducting its business. This legislation provides a narrowly tailored remedy for patrons to have a statutorily required hearing regarding objectionable materials where they must be heard, and where other patrons also have an opportunity to be heard, and to which the board must respond with a reasoned written decision that includes a testimony regarding relevant community standards, in addition to the material itself and the statutory definition of material harmful to minors found in 18-15-14-6A. The notice and hearing process develops a record which can be used in judicial review of the final decision, and it helps a court ascertain the community standards prong of the Miller test. The process also requires a request for reconsideration prior to jumping into judicial review, and it allows the board an opportunity to cure any procedural or other defects in rendering its decision prior to the case going to court, and it helps conserve judicial resources and keeps resolution of the issue at the lowest local level, while still affording aggrieved parties the right to obtain relief if other avenues have failed. One of the goals and one of the purposes of why we have libraries is to foster education, an informed electorate as the statutes provide for both city and county libraries, and in school libraries. The stability of a Republican form of government depends on the intelligence of the people. These libraries are vital. In 2015, my first year of law school, we had a visit from then District Judge John Stegner, now Supreme Court Justice Stegner, soon to retire. And he gave us a list of 10 things to do in my courtroom. And the fifth one, employ an educator's skill. So if the mission of the library is to educate folks, and we have all these accounts of instances of material harmful to minors, and some are well-grounded, some might not be. But how do you figure that out? How do you satisfy the person who is concerned about the material, and how do you satisfy the person who thinks there should be no objection to the material? And how do you balance those two things? You do that through the process of education. One of the things I do as a city attorney is I cover planning and zoning hearings. All of this procedure I stole from the Local Land Use Planning Act, including the right to judicial review. You have a notice and you have an opportunity to be heard, and then you get a chance to learn about whether the application in question does or doesn't meet the standards. So this is an opportunity for libraries and their patrons to all learn something about what the constitutional standards are for the material in their collection. And it's an opportunity for the persons attending the hearing to learn how their library is making their decisions at a hearing at which they have a right to participate. I gave everyone a copy of Idaho Session Laws 1976. So this was House Bill 618 that was passed in 1976 that amended the obscenity law with the express purpose of incorporating the Miller test, which is the constitutionally sound way of defining material harmful to minors. So when you hear discussion about what material is or isn't harmful to minors, you can read this. This is the definition, so you have it in front of you. That's the purpose of having this. A review committee is going to have to review the work as a whole. They're going to have to listen to and incorporate testimony about community standards. Now, I've heard some folks from different lobbying groups attempt to assail the constitutionality of one part of this statute, which has been on the books for 48 years. The part in question, which is purportedly unconstitutional and with which I don't necessarily agree, because the cases that speak to this are in the realm of criminal prosecution and with material available to minors, or not necessarily in that vein. The part that is objectionable, according to these folks, or that purportedly renders this unconstitutional, is the last part about whether or not a work possesses serious literary, artistic, political, or scientific value for minors. And then it goes on to say, according to the prevailing standards in the adult community. In other cases, the Supreme Court has said you can't use that. It's just an objective. It just does it or does it not possess literary, artistic, political, or scientific value for minors. So, even if that was to be held unconstitutional, which it's not, this statute in Idaho has not been challenged. And it's only a Supreme Court case that may or may not speak to it. And the dissent in that Supreme Court case, I would add, says that you can go beyond the constitutional limitations in some regards with this material. But the important part, this is the law that you're looking at. This isn't Idaho code. The law is the bills we pass. And the very important part about whether this is or isn't constitutional is contained in section 16 of this legislation.
We'll pause for a second while their order is returned to the gallery. Works better if my mic's on. If you're in the gallery, please refrain from talking or making noise. Thank you. Senator Schroeder, you may continue.
Thank you, Mr. President. So, even assuming that according to prevailing standards in the adult community is unconstitutional, Section 16 of the bill covers that because it says if any phrase, clause, sentence, section, or provision of this act or application is held invalid, it shall not affect any other phrase, clause, sentence, section, provision, or application of this act which can be given effect without the invalid phrase. It's called the severability provision. And so you can strike that sentence. And a legal advisor to a committee can say, when you're considering whether or not this work has literary or scientific, ignore the part about prevailing standards in the community, even if you were to obtain a constitutional challenge to it. So I think I've explained what the bill does. What the bill doesn't do is ban books. What the bill doesn't do is ban ideas. What the bill does is promote the exchange of ideas in order to answer a question, which is burning in everyone's minds. Is this material harmful to minors or is it not? Everybody picks up a phrase and calls something porn or pornography. Maybe it is, maybe it isn't. This provides a reasoned, deliberative process where you can answer that question and communicate and educate the person objecting to the work and communicate to the people who support the work. And with that, Mr. President, debate is open.
Thank you. Is there further debate?
Mr. President, to debate the bill.
Senator Herndon, you have the floor.
Mr. President, I just wanted to talk about some of the details of the bill that I'm just a little concerned on the actual process of the bill. And I'll just detail a few of them. My timeline is I've scratched out for the bill. By January 1st, 2025, the board will appoint a review committee. They could be on that review committee, so the library or school board could be on the committee itself. The board would create a form, then a parent would file a form when challenging a book, and then there's no time limit in the legislation by which the review committee would review the form and the request to consider the material. But then once the committee decides to do that, and assume the board is going to create a policy and maybe they'll have a timeliness to that, once they do that, hopefully the board will then create in their policy that they're going to tell the parent that filed the form that they're going to tell them about the public hearing that's coming up, because the legislation doesn't require the parent who filed the form to be notified. It only requires the committee to publish in the paper of record a 7-day notice that they're going to have a hearing. And then once they have a hearing, the legislation doesn't require that the decision of the review committee be made in any particular time limit. But they could make it that night, but then there is a requirement in the legislation that the decision be notified to the parent within and that the parent could ask for reconsideration within 7 days. My concern is that what if a parent files a form and they go on vacation because they don't know when this committee is going to meet, and they're on vacation and they're not able to attend their own hearing because they don't get personally notified of their own hearing, and hopefully the boards will take care of that. My other concern is that once the parent decides, if they do happen to get the notice and respond in time, that they want to appeal to the whole board. Let's pick a day of the month. Let's say it's the first Monday that they get that notice. Library boards and school boards don't meet very often. So to actually act as the appeal process to the review committee, the library and school board would have to meet, and they're only given 7 days in the legislation to review. And on a regular meeting, they need 5-day meeting notice to put this on the agenda. And if they hold a special meeting, they're going to have to get the whole library or school board together with a 24-hour notice to have this on the agenda, because the library or school board cannot act as a body and have a decision without an officially noticed meeting according to our open meeting laws. So my concern is that you get the decision of the review committee and the parent may not actually get a decision from a library board or a school board. And if they don't meet, then within the 7 days of when the parent asks for reconsideration, then it's considered that they denied the reconsideration. So the parent really didn't get that second step of review. That's a concern. It's the way the legislation's written. It's also going to be the practical reality on the ground. Maybe the school boards and library boards can come up with a way around that. I don't know. My next concern is after that denial at that reconsideration, we enter into the judiciary process, the judicial process, and we're using Chapter 52 of Title 67, which is the Administrative Procedures Act, which defines agency as state boards and state agencies and state commissions, and it doesn't define them as local political subdivisions. And I did talk to the Attorney General's office, and he said the way the legislation is written, it says on page 3 in subsection 5 that the parent may seek judicial review as provided by Chapter 52, Title 67, but Chapter 52 of Title 67 does not provide judicial review of library and school board decisions, at least on its face. So that's a concern that we're putting in Idaho Code language that is not technically there, and the Attorney General tells me, well, maybe the judge will liberally construe that we can use the procedure over there. However, I'd like to point out a problem at this point. So this could be the parent's first real appeal of the review decision. This could be their first one, and it requires them within 28 days of the lack of action by the full board or an action affirming the review committee's decision. The parent only gets 28 days to file a judicial action in district court. 28 days, because that's what's in the Administrative Procedures Act. And that would be at their cost. And there's no process in the Administrative Procedures Act where they can recoup any of those costs. So this is going to essentially make the parents the police of our libraries. That's what this does, at their cost. So if a review committee doesn't agree with them and the whole board doesn't actually meet to reconsider, and so the review committee's decision is final, the parent has to go to the district court. And I thought that we were trying to avoid things going to the district court, because I thought our courts were already too full. But if we accept that the Administrative Procedures Act authorizes judges at the district court to act on these appeals, they're all at our district courts. So every single challenge to every single book that a parent didn't like the review committee's decision is now sitting at a judge. And now, according to that act, the board, the library, or the school has 42 days to provide the record to the court. And then the judge is going to have to render a decision. So we've got a whole lot of judicial activity here. And I thought that's what we were trying to avoid. And it's at the cost of Idaho parents. And now I just think we're really in a position where the parents are going to be the police of their local libraries and schools. And the burden's entirely on them. And I wish we could do that differently. And then I'll just note that whatever the ultimate decision is at that point, and that's a may option for the parent. He doesn't have to keep going. He could have stopped before going to court. But whatever that decision is, at that point, that is the decision. The parent never gets to get this in front of a jury. So even in the court process, it's only confined to the judge. And if ultimately the decision is that it's not harmful to minors, which would be great, if the parent still disagrees, we just have to be clear that that's the end of the road for the parent. They can't ever then sue because it was never found harmful to minors by the review committee and by one judge. But again, I'm concerned it's going to clog up our court system. Parents are going to be confused. Hopefully boards will make the process really clear. Parents are going to have their attorney ready within 28 days to file paperwork at a district court if they disagree with their review committee. It sounds like a very bureaucratic, difficult process to me. And I wish we would have cut sections out of the APA, the Administrative Procedures Act, and put them over here so it's clear that the courts could act. And I just want to make sure the body knew that that's the situation we're voting on. Thank you.
Is there further debate?
Mr. President.
Senator Just.
To debate the bill.
You have the floor.
Senators, I want to thank the authors of this bill for bringing us the best bill yet we've seen on this subject. And I respect the good senator from one, his views on process. I think this is an unnecessary bill. There is no plague of pornography in our libraries. Every library in the state already has a process in place for challenging books. I trust librarians, but more than that, I put my faith in local control, and for that reason, I'll be voting no.
Is there further debate?
Mr. President,
Senator Robbie,
to debate against the bill.
you have the floor.
I also feel compelled to say something just because my mom was a librarian. The public schools out in Middleton where I grew up. I just grew up spending a lot of time in the library, Middleton Middle School, Middleton High School, and saw her bringing together groups of students to discuss really interesting topics. They would, each select a book and discuss that book. And my mom was voted Teacher of the Year multiple times. Every time I go out anywhere, even when I brought her here to the Capitol, she saw so many of her former students, Mrs. Robbie, Mrs. Robbie. And I understand, some of the issues, the concerns that what I believe is a minority of Idahoans bringing this issue to our body again and again. But I strongly believe, and I know that a majority of Idahoans stand behind our librarians and don't want to compromise on this issue. I really, truly appreciate all the work that the senator from District 8 has done on this, and appreciate the process that's been set out in this bill in a lot of ways, but I cannot ever support any potential injunctive relief to a librarian or to the library for simply doing their jobs. And even though this process has been set up, I do believe that it creates a financial incentive for people to cause additional chaos in our libraries, which is, I believe, and again, what I believe a majority of Idahoans believe, is that this is not an issue that we should be focusing on. I understand there are controversial books that have been brought to libraries and found in libraries, and certain parents have concerns about that. Again, appreciate all the work that has been done on this bill in particular, but it just comes down to the root of the problem for me that I think kids are getting harmful materials elsewhere. We talked a lot about the issue of phones this session, and that is where the root of the problem is, I believe, not in our libraries. So again, just want to stand up. I felt compelled to stand for my mom, what I believe are the majority of Idahoans, and where they are on this issue. I really would like to just let it lie and not have to revisit this again and again. Each library has their own processes in place for how they determine what is and isn't harmful. I do think these decisions can be decided at the local level. And by putting this injunctive relief in place, I just think we're harming a lot of people. We're going to be harming our librarians first and foremost, and I do think it will cause some of our beloved libraries across the state to have to make really hard decisions about their budgets and staffing and things of that nature. So I'll be voting against this bill or any other bill that is on this topic. Thanks, Senators.
Is there further debate?
Mr. President,
Senator Carlson,
to debate the bill.
you have the floor.
Senators, this is a huge issue. For me, I have worked really hard to try to pass legislation to protect children. Unfortunately, this legislation doesn't remove the material. You have to challenge the book in order for the material to be removed. And in addition, the process could take up to 6 months for each book. If each school or library has 50 books that might be harmful to minors, each school and library could be at it maybe 25 years from my calculations. I never intended to cause a friction between librarians and libraries, and this would make them hate us because they will have to provide the staff to deal with this issue. So therefore my debate is against this bill.
Is there further debate? Hearing none.
Mr. President.
Senator Winder.
Thank you, Mr. President. First of all, I commend the good senator from 8 for working so diligently on this issue. Many of you will remember I was a sponsor on the bill we had last year that was vetoed by the governor. I want to remind everyone that making law is a process. We don't always get exactly what we want. And for those of you who say you're not ever going to vote for a library bill, your opposition to a bill may not kill that bill. And you may end up with something a lot worse than's before you today. So I put that in your thinking and ask you to consider that. We have a part of orientation. I always talk to new legislators and I talk to constituents about the test, the 36, 18, and 1 test. 36 House members, 18 senators, and 1 governor to get a bill passed. We know the last bill we passed met the 36, met the 18, and was vetoed. What we have now is a cooperative effort between the 2 bodies to develop a bill that will again meet the 36-18 test. I can't guarantee it won't get vetoed, but I think it's got a lot better chance than the one where we were going to put potentially librarians in jail or fine them outrageous amounts of money personally. I think that this is a good effort. It's a good balanced effort. And I just really don't want to lose that thought that we as legislators don't necessarily get everything we want. Heard it in the opening prayer today. Sometimes we take a bite out of the apple. We don't get the full apple, but we take a step in the right direction. I think back to the arguments last year in favor of the bill that I sponsored, and it had the same kind of problems. It had some of the same language. This is a combination, I believe, of a due process and last year's language. Still allows for the private right of action once they've gone through the process. It eliminates a lot of chaos that could occur in the process that a library would go through to look at this. It gives our parents the right to go and actually make a complaint and have it heard. If you think about it, I mean, you can oppose this, you can vote against it, but I don't want to go home without a library bill. And I think this is the best we're going to get this year. So I'd urge your vote, and I believe it allows local control, just the way it's written. So I really ask you to think hard about what you might get if you don't get this one. Thank you.
Is there further debate?
Mr. President.
Senator Lenning.
To debate the bill.
You have the floor, Senator.
Thank you, Mr. President. I wasn't actually going to debate this, but listening to the senator from 20's concern, which I understand, we don't want to go home without a library bill. So let's just take a library bill. I don't think we should just take any bill. I think we should take the best bill, or a bill that everybody is if it's something we're going to pass, I believe it should be something we are proud to pass, that we want to vote for. And I know we all get emails on this specific topic, on this specific bill. I don't know what the number is. It's got to be over 1,000 emails and phone calls and constituents and meetings at the coffee shop. And it seems to, what I'm hearing from my district, and not just my district, but districts all over the state, is this doesn't seem like a library bill that people want. It just doesn't. I spoke to my precinct committeeman and district chair in my district, and I said, hey, what do you guys think of this library bill? And it came up short. And just my overall feeling from the feedback we're getting from our constituents, and I'm getting feedback from your constituents and vice versa, is that, hey, we just got to pass a library bill. Here's one. Let's just pass it so we can check the box and move on. And I just can't vote for a bill just for the sake of voting for a bill. Let's come back another time and pass something we can all be proud of. Thank you.
Is there further debate?
Mr. President.
Senator Harkin.
Thank you, Mr. President. You know, all of our districts are different. And my district is pretty much unanimous. We don't like library bills. They like their library. However, I have to agree with a good senator from 20. And I've wrestled with this back and forth and had my debate prepared to be exactly the opposite of what I'm doing now. You know, I talked with my superintendent last week, and he told me that for the first time in his 8 years as superintendent, they had a book that was challenged, and it was only challenged because they thought it was in the wrong department. Should not be in elementary, maybe middle school. They immediately met, they discussed it, everyone said, we agree. The parent was happy, she went home, the book was moved. That's how it's handled in my district. Unilaterally, that's probably how it's handled in most of your districts. I think public hearings are costly. They're a problem. I think that private right of actions actually make me want to never vote for a bill. But here's the thing. I too do not want something that's worse than this. I've called my librarians and said, you know, I'm gonna vote for this bill because I do not want something that stifles you more. They're good people. They're watching out for your children. Our library is the safest place in my city for the kids to go, and they're there all the time. So with that, I'm going to go ahead and vote for this bill. Thank you.
Is there further debate?
Mr. President.
Senator Winter.
Debate a second time.
Does anyone wish to debate the bill for the first time? Senator Winter, you're recognized to debate again.
Thank you, Mr. President. After I completed my debate, I received a phone call that misinterpreted my closing remark. My closing remark was not meant to be a threat. It was just to place the thought that this is a good bill. It's an effort that's been made by people with sincere efforts on both sides of this rotunda to come up with a solution. So there's no way that I meant it as a threat that you were going to get something worse if you didn't vote for this. But I also want to plant the thought that this is a good bill, and I'd urge your support. Thank you.
Thank you, Senator. Is there further debate? Hearing none, Senator Schroeder, you're recognized to stand and close the debate.
Thank you, Mr. President. Something I perpetually fail to do at the outset, and then it dawns on me in the middle of talking. But pursuant to Rule 39H, I'd like to declare that I work for a law firm that represents approximately 20 cities throughout the state that have city libraries and a number of countywide library districts in Idaho.
Your declaration under the Senate rule will be noted in the journal. Senator Anthony, for what purpose do you rise?
Mr. President, I'm sorry. I think out of an abundance of caution, I will declare under Rule 39H that I work for a city that operates a library.
Your declaration will be noted in the journal. Senator Lakey.
Mr. President, to add to the wave, my firm also does represent various cities that have libraries.
Thank you, Senator. Your declaration will be noted in the journal as well. Senator Schroeder, you're back in order to close the debate.
Thank you, Mr. President. It's been interesting to listen to some of this debate, but I would like to first address a concern that the senator from District 1 raised about the applicability of the Administrative Procedures Act. So it's correct. 67, Chapter 52, Title 67 doesn't delineate libraries specifically. But there's an extensive case law in Idaho about whether or not you get access to judicial review under the Administrative Procedures Act. And that case law says, absent a statutory grant, you don't get judicial review. You can't enact a county ordinance that grants you judicial review.
What's that got to do with
For example,
libraries?
67, 65, 21 in the Local Land Use Planning Act. Within so many days after all remedies have been exhausted under local ordinances, you may seek judicial review as provided in Chapter 52, Title 67, verbatim from the language that's in this bill. Also 50-222, annexations grant the right for judicial review. So the fact that it's absent from the Administrative Procedures Act is not what's dispositive here. What's dispositive is by enacting this, defining an effective person, and granting that right of judicial review the same way the Land Use Planning Act does, you're allowed to do that. It does require parents to police the libraries. That's what all of the prior bills that we have considered do. The parent finds the material. The parent says, "Hey, what's going on here?
Yeah,
what is
this?" $250 for every book. I got
so that's exactly right. There are a number of off-ramps by design in this legislation to prevent conflict or needless access to the courts. And this was kind of crystallized in an email I got from a librarian in a school district in northern Idaho. And she said that 90% of these problems are addressed by interacting with her patrons. And she can address the issue as to whether or not it's actually harmful, whether it should be moved. And there's nothing in this bill that prevents a library from proactively taking steps
I looked at it, it was no big deal to me.
Subcategorize age-appropriate materials and ultimately to take material that is harmful to minors as defined in the statute and put it in a place where it's not accessible to minors. So here's a list of all the off-ramps on the freeway that we're headed down with this legislation. The first one is the library's curation policy, or how they categorize or group things for age appropriateness. The second one, regarding the senator from District 1's concerns, is the same way that you operate at a retail counter for planning and zoning actions. You show up and you say, I would like to get on the calendar, I want to process this conditional use permit application. So the same thing would happen at the counter with a library staff person.
That's why we have library
you object to this material. Here's the form, here's the definition of material harmful to minors. Let's have a discussion about how you're going to fill the form out, what's going to occur here.
So you're going to do it from the legislature, eh?
The Local Land Use Planning Act is also silent on how soon you have to schedule these hearings, what the notification is. But that's the purpose of being silent on this and allowing the library to adopt its own policies about how often they schedule and hold these hearings. So they needn't have a separate hearing for every single book. They can group them up. But you could have a discussion at the counter that would eliminate the need to even have the hearing.
A used car from you, fella.
Okay. Wow, I did not know we had that book. Let's move it over here. That's great. We're going to keep the book in the adult section. Or, oh, wow, I didn't realize that this was the standard. Maybe you don't need to move the book. Could you possibly sub-segregate it so that it's in an area more age-appropriate? And again, this is part of the education process. So that's the second off-ramp. The third off-ramp is having the public hearing and the reasoned written decision. Another opportunity to educate folks and another opportunity to avoid having to have this go to court. The next off-ramp is the opportunity to reconsider the decision. Hey, I think you got it wrong. I don't think you used the proper standards.
My goodness.
They have an opportunity to cure it there.
You know, Ben Franklin created libraries, I think.
This
Carnegie,
facing the prospect of this
he
process
spent a lot of money. Andrew
incentivizes the
Carnegie
library
back in
to engage more
1900 created
proactively,
Carnegie
possibly than we already
Libraries.
are. Not
Funded a
impugning
lot of money
any
along
library
with
that doesn't
Rockefeller
do
and
it.
the rest of them.
But given the amount of feedback that
He
we have
repealed,
about what
allowed
purportedly is going
the
on,
cities or
I
the
believe this
libraries
helps
where the
incentivize
where they're
libraries to
located
correct
to
that.
determine what they're going to put in the libraries. And what are you
I heard a
guys
lot
doing?
of criticism over the past month or
If
so
you ban books,
that this library
when
bill
are you
is
gonna
somehow
stop
watered
there?
down or some sort of a compromise.
you argue about not banning
Maybe it was a spur of the
AR-15s
moment, unfortunate choice of words by someone.
because it takes away
But it
your
is-
Second Amendment rights. It ensures the
House
First
Bill
Amendment.
384
Why is this? This is an amendment that takes away the
was-
First Amendment rights.
Mr.
Well, this is a
President,
law that takes away a First
request
Amendment right.
permission to quote from the Idaho Republican Party press release from Dorothy Moon on January 18th, 2000.
Having cited the source, Senator,
Oh, we got to listen to Dorothy.
proceed with caution and quote.
Thank you, Mr. President. Our state party chair said she was proud of Representative Jaron Crane of Nampa, who sponsored House Bill 384. What happened was that bill was held in order for the sponsor and I to work together. And that bill remains intact in this bill. What we've done is substituted the beginning part of that bill with the process here that incentivizes the
Mr.
library
Crane,
to
he's
correct
been in
anything
it
that could
too
be
long.
inherent.
There's the cranes
if
and the
that doesn't
cranes and the
work,
cranes
to
that
go through
seem
this
to have parked
process
their
and
butts in the
ultimately,
legislature.
if the library still doesn't do it, get the other remedies
Pretty
in
good
House Bill
job.
384.
$13 billion
This
a
is
year.
good bill. It's not a compromise.
Yeah, what else you got to say, bub?
I don't have anything else. With that, Mr. President, debate is closed.
Wow, I'm
The
surprised.
debate is
you got-
closed. The question before the Senate is, shall Senate Bill 1289 pass the Senate?
Okay,
The
listen to the
Secretary
vote.
will call the roll.
Adams. Anthony. Burnt. Bierke.
Mr. President.
Senator Berkey, having not debated, you have 60 seconds to explain your vote.
Thank you, Mr. President. I definitely feel that the work that the good senator from District 8 has done on this bill has been fruitful in the sense that it provides for a process. And I understand the concerns on both sides of this issue. But this is one of those times where just the immense amount of support against it from my constituents is going to keep me from voting aye on this, so I will be a nay vote.
Senator Berkey votes no.
Burtonshaw. Carlson. Cook. Ten Hartog. Foreman. Grove. Guthrie. Harris. Hart.
Senator Hart.
I'd like
you have
60
seconds.
Thank you, Mr. President. After listening to the debate and hearing more about the bill and the mechanics of the bill, what comes to my mind is a New Testament verse, Luke 11:46. I'll paraphrase it just slightly. Woe to you lawmakers, for you load people down with burdens too great to bear. I think we can make this simpler. I think we need a simpler library bill, so my vote is no.
Senator Hart votes no.
Hartkin. Herndon. Just. Lakey. Lee. Lenny. Lent. Nichols.
60 seconds, Mr. President.
Senator Nichols, you have 60 seconds to explain your vote.
Thank you, Mr. President. Based on the responses that I've been getting from my constituents and understanding the process of going through government, especially in regards to other things that I have been involved with permits and fees and how the ball is dropped quite often during those processes, I think this is a very convoluted approach to trying to help families and help parents go through a process. And so with that, I will be voting no.
You know, they're keeping track of the votes on their computers as the roll call is given.
Robbie?
And all they need is 18 votes to pass out of the 35.
Samarath?
So we'll see what the 18 votes
Taylor?
are. And the Republicans that are saying,
60 seconds.
okay, now let's listen to this guy. He's keeping track too.
60 seconds to explain your vote.
Thank you. Thank you to the senator from District 8 for working so hard on this. I personally don't think that there's a problem and that we keep kicking this dead horse a little too much. My constituents have asked me to vote no on this, and I agree with them, so I'll be voting no.
Senator Taylor votes no.
Good.
Taves? Trakel? Van Orden? Ward King?
Mr. President, 60 seconds.
Senator Ward King, you have 60 seconds to address the body as you explain your vote.
Thank you, Mr. President. My entire career has been spent protecting children, and almost every day I worked with the librarians, and I have to say that they are in that job because they love reading books and children. And our libraries already have review processes in place. And I'm looking at the 9 steps and the possible private cause of action or bounty in this. And this bill could devastate some small schools and rural libraries. So this senator will vote no.
Senator Ward King votes no.
Winder? Winthrow? Seiderveld?
Here again, all he needs 18.
Lakey? Samarath?
Mr. President, 60 seconds.
Senator Samarath, you have 60 seconds to explain your vote.
Our librarians, I always call them our walking First Amendments. They are committed to the privacy of access to information for their community members. They already have processes in place. This legislation provides one more level of protection for the community, so in a process that everyone can understand and access. With that, the Idaho Commission of Libraries will need additional support to ensure there will be proper resources and staff to help support the implementation of this bill. The senator votes aye.
Senator Samarath votes yes.
Taves? Winthrow?
60 seconds, Mr. President.
Senator Winthrow, you have 60 seconds to explain your vote.
I'll try to, obviously I only have 60 seconds to be brief, but I think the problem with this bill and many others is the problem isn't the process, the problem isn't the library, and the problem isn't the librarians. The problem is the complaints that are coming probably out of ignorance about the content. And many of the titles that have been challenged are about gay and lesbian characters and issues about racism. And so for that, I think we need to address the specter instead of this. So the senator votes nay.
Senator Winthrow votes no.
Seiderveld?
60 seconds, Mr. President.
Senator Feld, you too have 60 seconds to explain your vote.
Thank you very much. So as I'm listening to the debates in the 60 seconds, the one thing I haven't really heard a lot about is protecting our children. It's protecting the libraries, protecting the laws, protecting the process, but we're not protecting the children. This makes it too complicated for parents to protect their children. We need to make it simple, we need to make it clear and easy, because at the end of the day, it is about protecting our children, and the senator votes no.
Senator Feld votes no.
See if they get the 18.
The vote count shows 17 in favor with 18 against, fewer than a majority having voted in the affirmative. Senate Bill 1289 has failed to pass the Senate.
All right.
It will be retained in the office of the Secretary.
Mr. President,
Senator